We're at trial. It's a medical malpractice trial, and you are suing your doctor. I'm now cross-examining the doctor that you have sued. And I ask this question: Doctor, isn't it true you've been sued 10 times by other patients? The defense attorney flips out. He jumps up, he yells out, "Objection, Judge! That's prejudicial!" You want to know why the attorney is objecting? And what's going to happen to me for asking that question? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So now I'm in the middle of cross-examination. I'm asking the doctor who you have sued, the defendant, certain questions. And I know from doing my research that this doctor has been sued many times before. Is it appropriate for me to ask the doctor whether he's been sued 10 times before? The answer is no, it's not appropriate. Why not? It's because the mere fact that someone has sued this particular doctor does not mean, number one, that this doctor is legally responsible for that person's injuries. Unless, of course, that particular case went to trial, it resulted in a verdict, and now whatever appeal occurred confirmed the jury verdict. Only then can I turn around and say, "Hey doctor, in this particular case, a patient sued you, isn't that true?" Yes. And the jury came back with the following verdict, isn't that true? Yes. Now, in that instance, where you have a resolution, a finality to a particular case, now I can use that information. But the mere fact that somebody has sued the doctor and does not have a final answer as to whether or not the doctor is legally responsible, it would be irresponsible for me to go ahead and ask that question. Let me give you an example of how that might apply in a case where you're driving down the highway and you get pulled over by a police officer. The cop tells you, "Listen, you were speeding. You were doing 80 in a 60-mile-an-hour zone." And you say, "No, I wasn't." And the cop looks at your driving record and says, "I see that you had 10 speeding tickets in the last year. Therefore, you must be speeding now." And now you begin to recognize, hey, the mere fact that you had those other speeding tickets doesn't mean that you were speeding in this particular instance. Same thing in the malpractice case. So, if the attorney jumps up and objects, which he definitely will, now I'm going to get yelled at by the judge for asking what clearly is a prejudicial statement. And in all likelihood, the judge will then have to explain to the jury that the mere fact that a doctor has been sued is not indicative of anything unless there's a finality to the particular lawsuit. So why do I share this information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.